Good morning, friends. Welcome to the lectures on law of torts. The topic for this session is concept of a defamation. This session is provided to you by Dr. Deepak Miglani and Miglani. It's a very important session for the students who are going for judicial services examination, NET, CLAT, LLB and LLM students, because law of torts is a very important part. Number of questions are being asked from in the judicial services as well as NET examination. You may connect us on our Facebook at Dinesh Miglani and Deepak Miglani. My WhatsApp number 09215514435. For any query, you may send email to me at legalbuddy@gmail.com. You may also subscribe our YouTube channel @LegalPoint, our website www.legalpoint.in. I expect from you to share these videos on your Facebook wall as well as with your friends so that they will also be benefited by this. Let us start with this session, the concept of defamation. Before starting with the session, first of all, I just want to give you a brief introduction about what we are going to study in this session. In this session, first of all, we try to understand what is the definition of defamation, right? We use two terms here. One is libel and second one is slander. As well as we try to understand the difference between libel and slander, right? Next, we try to understand what are the essentials of defamation. What are the various essentials of defamation, right? For checking whether it is a defamation or not, what you have to check. In that, we will study about words must be defamatory, right? Second essential, it must refer to plaintiff. We will just discuss all this in a detail, right? And third is words must be published, or we can say publication of words. Publication of words, right? These are the primary three essentials that we discuss in this session. As well as we also discuss what are the defenses available for defamation, what are the defenses available to the defendant for defamation, right? In this we will study about justification of truth, about justification of truth in the statement, as well as we will also study the defense of fair comment. Similarly, number of privileges are available to us, right? That are divided broadly in two categories. The first one is absolute privilege, right? And the second one is qualified privilege. We also try to understand the meaning of the term absolute privilege and qualified privilege. As well as we also understand the burden of proof, means in a case of defamation in law of torts, on whom the burden of proof is, whether it is on plaintiff or it is on defendant, right? So this is a brief introduction to our topic. These things we are going to study in this chapter, right? Let us start with the chapter. The first concept that we are going to start with about the meaning of defamation, right? In general sense, when I talk about the defamation, it means injuring the reputation of some person, injuring the reputation of some person. As we know that everyone has a right to reputation. Everyone has a right to reputation, and when that reputation is injured by any person, either by some statement or by any action that directly or indirectly affects the reputation, in that case, an action can be against the person under the concept of defamation, right? In a case, Dixon versus Holland in 1869, it is observed that the reputation is a property of a man. Reputation is basically property of a man, right? And it is the most important property of the man, right? And we can say that is the property of a man. It is the most valuable property that a man can have, because generally it is stated that if reputation is gone, that would affect the man morally as well as mentally, right? So in the case of Dixon and Holland in 1869, importance of reputation was discussed. Similarly, a definition is given by the Winfield about what you mean by actually defamation. Let us try to just read the definition. Publication of a statement which tends to lower a person in the estimation of right thinking members of the society, or which make them shun or avoid that person. Now, what is specified by the Winfield? When I just observe the definition of the Winfield, Winfield stated that first of all there should be publication of the statement. Publication means it should come to know to the society, to some persons of the society, right? And the second thing that is very important stated by the Winfield is, what is a defamation is something in the right thinking members of the society, in the eyes of right thinking members of the society, right? If that causes the reputation of a person, that affecting the reputation of a person, so that is basically said to be a defamation, right? It is not the injury which a man may suffer himself. It also includes the injury to his wife, to his children, right? Or anyone who is directly connected with that person. Okay. So thus what we can say that the defamation is primarily injuring the reputation of a person, which may be either by publication of a matter, it may be by communicating, by making some cartoon or anything else, right? And that must be in the right thinking member of the society is a defamation, is said to be defamation. Next, we just try to understand defamation is a civil as well as criminal wrong. Is a civil as well as criminal wrong. Civil wrong, that is right to compensation under law of torts. Criminal wrong in India under IPC article IPC section 499. Section 499 provides for the defamation. What causes the defamation under Indian Penal Code, right? A person can institute a criminal proceeding in case of a defamation against the writer or a publisher, or he can sue a civil suit under the law of torts, right, for injury that he has suffered. Okay. The law of defamation, like many other branches of law, in that what we do, we generally make a balance between the reputation of a person and the freedom of speech and expression, right? Means everyone has a right to reputation as well as everyone has a right to freedom of speech. Okay, so in that we just try to make a balance between that right to reputation and freedom of speech. Up to what extent the freedom of speech can be used so that the reputation of a person is not affected, right? So there, in the concept of the defamation, we have to maintain a balance between the right to reputation and freedom of speech. Okay. Similarly, the defamation is a reasonable restriction on the fundamental right of freedom and speech and expression under Article 19(1)(a), right, as well as is saved by Article 19(2), under which some restrictions are given on the freedom of speech and expression, right? So basically, when we try to understand the concept origination of the concept of defamation, the origination can also be observed from the Constitution of India under Article 19(1)(a), as well as under the Article 9(2), where it has been stated that everyone has a right to reputation as well as everyone has a freedom of speech and expression. Next term that we use is libel and slander, right? In English law, for the defamation we use primarily two terms. One is the libel and second one is the slander. Let us try to understand the difference between the libel and slander. When we talk about the term libel, libel is a representation made in some permanent form, right? Made in some permanent form. The permanent form may be in writing, it may be in printing, it may be making of some picture or effigy or any statue or any cartoon, right? Or any cartoon, that is said to be libel. Okay, so what we can say that when the representation is made in some permanent form, that is said to be libel, right? On the other hand, when we consider the slander, slander is publication of a defamatory statement in transient form. In transient means in ephemeral form, means not we can say in momentary form. In momentary form, not for too long time, right? Only for short span of time, right? It may be by spoken words, it may be by spoken words, or it may be by some gestures, right? For example, slander is like rumors, right? It may be gossips addressed to the ears to the listener. Okay, so here now we can easily understand the difference between the libel and the slander. That difference has been made under English law, not in Indian law, right? The libel for permanent form and slander for short form, or we can say for momentary form. Okay. Now what we can say that slander is a rumor or a gossip. That is the basic difference between the slander and the libel. Slander is generally heard by ears. Slander is generally heard by ears. On the other hand, when we talk about the libel, it is addressed to the eyes, because when a picture have been made, a statue have been made, right, or a cartoon have been made, that could be seen by the eyes, right. Libel is a civil as well as a criminal wrong. Okay, when some cartoon or some picture have been made, for that we may go for civil as well as the criminal action under English law, right. But for slander, only civil wrong is it's merely a civil wrong. No criminal action can be taken in slander. Okay. In India, weight of the various decisions in India is to make slander like libel as well actionable personally. But when we talk about in India the situation is same, right? In India, we don't find any distinction between the slander or the libel as respect to the action taken, right? But one thing is you have to take care that limitation period is given in India for libel and slander. Both the limitation period is 1 year, right? We cannot say that goes for perpetuity. For example, if someone has called you a bad name, or someone has made a statement against you, which causes to injure your reputation, so you cannot go to the court of law for whole life, right? For that, one limitation period is provided. That limitation period is of 1 year, right? So that is about the defamation, right? So what we have understood here till now, we have understood here the meaning of the defamation, the definition given by Winfield, the meaning of the defamation, as well as the definition given by Winfield, in which he talked about two basic things. One is the publication, and the second thing is reputation in the right thinking member of the society, right? After that, we understood the meaning of the term libel as well as slander. The both terms are used under English law, right? Libel for some permanent form, right, like cartoons, like making pictures, statues, right. And slander, when we talk about the term slander, that is in short span of time by gossips, right, or by making some comments which may be heard by ears, right. So that is the difference between the libel and slander. Under English law, the difference have been made. Libel, both civil and criminal action can be taken. Slander, only civil action can be taken, no criminal action can be taken, right. But in India, the situation is different. In India, no distinction have been made between the libel and slander, right. Only there is a limitation of 1 year for libel and slander for making them actionable, right. Let's have the next point here that deals with the essentials of defamation, right. What are the different essentials of defamation? Practically, for making any statement or either libel or slander to be under the purview of the defamation, the three essentials are required. First one is the words must be false and defamatory. It may be something that injure actually the reputation of a person. Second one is the said words must refer to the plaintiff, right. It does not mean that if I if I say about some other one person and he may go for the case of defamation, it must be towards the plaintiff, right. And the next word must be published, or we can say publication of the words, right. Let us take all the three essentials one by one, as well as try to understand the different other aspects that have been taken in this essential. Let us start with the first one. The words must be defamatory. Okay. Now, when I say words must be defamatory, the first of all we have to understand the meaning of the term defamatory statement, right? What do you mean by the term defamatory statement? Defamatory statement is something which tends to injure the reputation or character of the plaintiff, right? Injure the reputation or character of a plaintiff. It is something which may either be in words, right, or which may either be in pictures that directly or indirectly affects the reputation of a person. That statement is said to be defamation person, right? And when we talk about that a defamatory statement, as the definition given by the Winfield, it should be something how the right thinking member of the society take it. Here the major point is how right thinking member of the society take it. Right thinking members of society take it, right? In the eyes of those, whether the statement seems to be defame the reputation of a person or not, that is said to be defamation. Okay, the standard to be applied of a right-minded person, a man of fair average intelligence, right? A statement is said to be a defamatory as per to the definition given by the Winfield, where if most citizens would shun or avoid a person in consequence of the statement, right? It means if I say a statement, most of the citizens of the society don't like that statement, right? And next one is a substantial and respectable proportion of the society would think that low of a person. Means समाज के ज्यादा से ज्यादा लोग अगर ये समझे कि वो जो स्टेटमेंट दिया गया है इससे आदमी को नीचा माना जाए या उसकी रेपुटेशन इंज्योर हो, तो इन दो केसेस के ऊपर हम क्या कह सकते हैं, व्हाट वी कैन से दैट द स्टेटमेंट्स वर्ड्स आर सेड टू बी डिफेमेटरी टुवर्ड्स द पर्सन. ओके, नो एक्शन for damages for mere insult. Mere insulting of someone, it does not go for any, we can say it does not go for any defamation. Okay, but when a statement causes anyone to be regarded with feelings of hatred, contempt, ridicule, fear, dislike and disesteem, that is said to be defamatory. Okay, means when a statement is being made with a feelings, means here the idea is with an intention, or we can say with a feeling. Intention is something different, but here we are concerned with a feeling of hatred, right? With a feeling of hatred, right? Similarly, it should be with a feeling of contempt, ridicule, right? All these lead to ridicule. All these leads to defamation. Okay. Next we have insulting words are also like to cause ridicule and humiliation, and so they are said to be actionable, right? Further, to say that a product does not answer in purpose is not a defamatory, but to say that baker's bread is always wholesome, unwholesome is said to be defamatory. Primarily here the meaning is that one, from the statement, from the language of the statement as well as the feeling that is inside the statement, will check whether the given statement given is a defamation or not. Let us start to discuss a case, South India Railway Company versus Ramakrishna 1890. Right, it's a case. Before starting with the actual facts of the case, let just try to explain you in general sense what happened. एक ट्रेन में एक आदमी यात्रा कर रहा था, ठीक है. टिकट चेकर आता है उसके पास में, राइट, और टिकट चेकर उस पे अपना शक शो करता है कि आई हैव सस्पिशन दैट यू डोंट हैव अ टिकट, राइट. नाउ ऑन दैट स्टेटमेंट दैट पैसेंजर stated that it's a case of a defamation, right, and he went to the court of law, right. There it was stated that mere showing suspicion will not lead to a defamation. Okay, so hence in that case the statement by the ticket checker that because with the statement he shows a suspicion on the plaintiff not having a ticket does not causes defamation, right. Now just take the case in actual way. The railway guard, there was a railway guard, right, he was checking the tickets, and while checking the tickets he called upon the plaintiff to produce the ticket, right, and in presence of other passenger what he said, I suspect that you are traveling without ticket. Means he shows a suspicion on the plaintiff before the other passenger that you don't have ticket, right, but the plaintiff produced the ticket, right, which was in order, right. Okay, what we can say that hence the words spoken by the guard were not bona fide, right, and under the circumstances the case is not a case of defamation, right. So that is our first case, South Indian Railway Company versus Ramakrishna 1890. Similarly, one more case is there, Sim versus Stretch in 1936. What happened in this case? In this case, पहले जनरल समझे, there was a maid, right, she was working at some place and she left that work, right, and she joined some other persons. Now the other person sent a telegram to the first owner that pay the dues of the maid. Pay the dues of the maid, right? And that plaintiff went to the court of law by saying that the statement by the other owner is a defamation, right? So in that case, because that statement or telegram simply asking the defendant to pay the salary of the maid does not a case of defamation, right? What happened? The plaintiff housemaid left service and joined the defendant. In the telegram by the defendant, it was written, Edith, the name of the maid, has resumed her services with us today. Okay. And please send her possessions and money. Please send her possession and money, right? The plaintiff claimed damages as it's a case of defamation. The words are defamatory, right? That stating that they are implied that the plaintiff was not in such a financial condition that they will pay the money to the maid, right? But it was held that words were not reasonably capable of any defamatory meaning. Okay, so what is that? For checking any court of law whether the words are under defamation or not, they must be capable of defamatory meaning. Here one thing very important to us, that the words must be capable of defamatory meaning. In that case we can say that they will cause the defamation. The words must be capable of defamatory meaning, right? Only in that case we can say they are the case of defamation, right? So similarly in Sim versus Tech, it is not a case of defamation, right? The next very important term to understand here is that is said to be innuendo, right? So we have earlier understood two terms. One is the libel, right? And second one is slander. Now after the libel and slander, the next term that is important to understand here, innuendo, right? Let us try to understand the term. Sometime a statement is stated which is prima facie and innocent. Practically prima facie in an innocent, in general, in natural meaning, that seems to be innocent, but because of some latent or secondary meaning, it may be considered to be defamatory. But when we go in depth, when we try to understand the secondary meaning or the latent meaning, that is said to be defamatory. In that case, that type of statements are said to be innuendo, right? एक जनरल से एग्जांपल से लेते हैं. फॉर एग्जांपल, अगर मैं एक स्टेटमेंट दूं, मिसिज एक्स bears a son, a son was born of Mrs. X, right? That statement is given. No, a defamation is caused, right? It's not an innuendo, neither it's a libel or slander. It's not a case of defamation, right? But if I say a son is born to Miss X, a son is born to Miss X. Now, when I just state this statement, this is not a defamation, but because Miss X, Miss unmarried girl, and if I say that a child is born to an unmarried girl, secondary meaning is defamatory to her, right? So that is a case of innuendo, right? मतलब कि एक शादीशुदा औरत के बारे में अगर ये बोला जाए कि उसका बेटा या बेटी पैदा हुई है, तो वो डिफेमेशन नहीं है. बट अगर लड़की अनमैरिड है और उसके बारे में बोला जाए ए चाइल्ड वाज बोर्न टू हर, तो दैट इज ए डिफेमेशन, राइट? तो प्राइमा फेसी इट्स नॉट इन द प्राइमा फेसी it's not a defamation, it's innocent statement. But if we go into the latent meaning, that is said to be defamation. I hope the idea is clear. So what do you mean by the term innuendo? Means a statement that is prima facie is an innocent statement, right? No case of defamation. But when we go into that, when we try to find the latent or secondary meaning of the statement, it may be considered to be defamatory. So that particular statement is said to be innuendo, right? And it's a case of defamation. Okay, let's try to understand with a case. The case is Tolley versus J.S. Fry and Sons, 1931, right? Tolley versus J.S. Fry and Sons Limited, 1931. What happened? A defendant issued an advertisement about a famous golfer as a caricature playing golf with a pocket of chocolate, right? Protruding from his pocket and a comic caddy saying that the chocolate was excellent as the plaintiff drive. Here the statement is chocolate was excellent. Chocolate was excellent as plaintiff drive. As plaintiff drive of golf, right? That statement, that ad was held to be defamatory. right? It's under innuendo, although prima facie that does not seem to be any defamation, right? But when we go into the secondary meaning about that chocolate and the caricature of the golfer, right? So that ad was said to be defamatory, right? In case of defamation, intention to defame is not necessary. Important point here is intention is not necessary. Feeling of the words must be such that they show the feeling of defamatory, right? But there is no need for any intention to defame is not necessary when the words are considered to be defamatory by the person to whom the statement is published. That is a defamation, even though the person making the statement believed it to be innocent, right? So here important point is there. No need to go into the intention. No need to check intention, right? It is exception to the principle of mens rea. It's exception to the principle of mens rea, where for every criminal proceeding, bad intention is required. Bad intention to do an act is required. But in case of defamation, intention does not play any role. Only the publication of the statement goes into the defaming a person. So in that case, that is a case of defamation, right? A very famous case in that, Cassidy versus Daily Mirror Newspaper Limited, 1929, right? Before going with the facts, I just want to explain you with an example, right? One person is there, we may talk it as Mr. C, right? He was in dispute with her wife. Okay, sometime he goes to her wife and stays at his home. What happened? A photograph of Mr. C and one more girl, Miss X, was published announcing their engagement, right? Now that action have been taken by Mrs. C against the newspaper, stating that still they are married, they have not taken the divorce. Now if you publish a photo in your newspaper announcing my husband's engagement with Miss X, simply states me that I am living in adultery with my husband, right? So that is an innuendo was established, although prima facie it's not a defamation. But when we go into the secondary meaning, means still I am married with my husband, and you are with the help of the newspaper by a statement saying that my husband is going to marry with some Miss X, right? If my husband is going to marry Miss X, in that case, prima facie it does not show any defamation, but in general opinion would be formed by the public that I am living in adultery with my husband because my husband is going to marry with someone else, right? It means stating that innuendo was established, I am with an immoral cohabitation with my husband, so that's why an innuendo was established and action was taken, right? So what we can say that Mr. Cassidy did not live with her lawful wife, but occasionally came and stayed with her on her flat. The defendant published in their newspaper a photograph of Mr. Cassidy and Miss X with the following words underneath. The words were stated as Mr. M. Cassidy and Miss X, whose engagement has been announced, right? In that case, her wife, Mrs. Cassidy, sued the defendant for libel, alleging that innuendo was that Mr. Cassidy was not her husband and he lived with her an immoral cohabitation, right? And innuendo was established, right? It's a standard case for showing the actual meaning of the term innuendo, right? Now after that, with the discussion of this particular case, Cassidy versus Daily Mirror and Newspaper Limited, as well as Tolley versus J.S. Fry and Sons Limited, as well as my earlier example about bearing of a child by a married girl as well as an unmarried girl. So with that we can easily understand what actually you mean by the term innuendo, right? Let's start with the second essential of the defamation. The words must refer to the plaintiff. The second essential is words must refer to the plaintiff, right? In a famous case, Hulton and Company versus Jones in 1910, what happened? An article was published in a newspaper, right, with a fictional name, and a person of the same name also existed in the society, right? And when the friends of that person read that article, because the facts of the article were as same to that fictional person, right? And the friends of the person read the article, they believed that the article referred to him, right? the defendants were held liable, right? So what is stated that in that case, the defendant newspaper published a fictional article in the newspaper by which imputation were cast on the morals of a fictitious person named as Artemus Jones. One name of the person, Artemus Jones, that was provided as per to the case. A real person also there in that particular name, and facts of the case were also same with the facts of the life of the person. Okay, and when the friends of that Artemus Jones read that article, they found that the person is to be the same. In that case, the defendants were held liable, right? So that was the case of Hulton and Company versus Jones of 1910. Okay, so it means that the words must refer to the plaintiff. Okay. Section 4 of Defamation Act of 1952 of England, it lays down the procedure by which an innocent author or publisher can avoid his liability, right? In India, no such particular thing is there, but that is Defamation Act 1952 of England talks about how an author, innocent author or a publisher can avoid his liability, right? 2 points have been there. An author can avoid his liability. First, he published innocently. He published innocently without any intention to defame the person, right? And the second thing is that once he comes to know about the fact, immediately he offered an apology. Immediately he offered an apology, right? If he offered an apology, that means that first that simply proves that he don't have any intention to defame the person, right? So two things, if that two things have been fulfilled, in that case the person can avoid his liability. The law in India is also the same, although no standard particular point has been given, but Supreme Court and other high courts also applies that particular law in case of a defamation where innocent author tries to avoid his liability. Two things have to be checked. First one is it should be innocently published, and the second one is that once it is published, once it is come to know to the author or publisher, immediately he offers an apology, so that proves his innocence, right? Next, we have few standard things. The first topic here is defamation of a class of a person. Defamation of a class of a person, not to a particular person, but to the whole class, right? As we know that the defamation is an injury to a man's reputation, which is right in rem, right? A man's reputation. Okay, but sometime a statement is given against the whole class, right? So what we can say that in that case, the reputation of law of torts is towards an individual, not to a class of person. For example, if someone says that all lawyers are not good, all lawyers are bad, right? So here no particular lawyer can go and sue that person. The reason behind it that because he is not saying anything about a particular person. If a particular person proves in the court of law that the statement given by the person is specifically for him, in that case, that's a case of a defamation. Otherwise, it's not a case of defamation, right? Similarly, if I say that all doctors are thieves, so no particular doctor could sue him unless there are something to point a particular individual, right? Let's just start with a few cases here. First case I am taking that defamatory statement towards the spiritual head of a community. Defamatory statement towards the spiritual head of a community. In that case, an individual of that community does not have a right to action. In that case, individual of that community does not have a right to action, does not have a right to action. For example, if I speak something very bad about the religious head of any particular community, right? In that case, spiritual head or any particular community, so that any individual of that community cannot make a case against me, right? They cannot sue. Only the head of that community can sue against me. Okay, so here I can say that no suit of defamation is maintainable. Similarly, in case of defamation of a partnership firm, no case of defamation of a partnership firm is maintainable, as partnership firm is not a legal person. Partnership firm cannot go for the case of defamation. The reason behind it, because partnership firm is not a legal person, and under law of torts, man's reputation right is for the particular person, right? In that case, individual person cannot say, individual partnership firm cannot go for the case of defamation, but a partner suit is maintainable. If a particular partner goes in court of law, right, and he files a suit, that suit is maintainable, right? Similarly, third case we take, that is defamation of a deceased. Okay, the defaming a deceased person is not covered under tort. Under criminal law, it may amount to defamation to impute anything to a deceased person if the imputation would harm the reputation of that person if living, and is intended to be hurtful to the feelings of the family or near relatives under section 499 explanation to IPC. Because as I earlier told you that our Indian Penal Code section 499 also talks about the defamation, where it is stated that whoever by words either spoken or intended to be read or signs or any visible representation makes or publishes any imputation concerning any person, knowing or having reason to believe that such imputation will harm the reputation of such person, is said to defame the person, right? Exception, explanation 1. Explanation 1 talks about that defamation of a disease. It may amount to defamation to impute anything to a deceased person if imputation would harm the reputation of the person if living, and is intended to be hurtful to the feeling of the family or other near relatives, right? तो सेक्शन एक्सप्लेनेशन 1 ऑफ 499 क्लियरली स्टेट करता है, अगर किसी मृत आदमी के बारे में, किसी मरे हुए आदमी के बारे में, किसी डिसीज आदमी के बारे में अगर कोई ऐसी स्टेटमेंट दी जाती है, अगर वो आदमी उस टाइम पर लिविंग होता और वो उस स्टेटमेंट से डिफेम होता, या उसके परिवार के सदस्यों की फीलिंग डिफेम होती है, सिमी फीलिंग हर्ट होती है, तो दैट इज ए केस ऑफ डिफेमेशन दैट इज बीइंग प्रोवाइडेड अंडर explanation 1 of section 499 of Indian Penal Code, right? But in law of torts, no action of defamation is taken in case of defamation under of the deceased, right? So under criminal law, a remedy has been provided, but law of tort does not provide any remedy for the defaming of a person who is a deceased person, right? Next, we have the third essential for a defamation, that is the words must be published, right? That is the publications of the statements of defamation, statements or any cartoon or any picture. Okay, what do you mean by the term publication? The publication means making defamatory matter known to some other persons other than the person that have been defamed, right? So here very important term is there, that is some other person apart from the person to whom you are going to defamed. Some other person must also know about that defamatory statement, because that simply states about the defamation. If A abuses B, it's not a defamation of B, right? But if C is present there and if A said something defamatory to B, so that is a case of defamation, right? It is a defamation only when two or more persons are involved. So here the major point is that when two or more persons are involved, that is said to be a case of a defamation. Sending a defamatory letter to the plaintiff is not a defamation, right? If I send a letter to a plaintiff and that is not a case of defamation, it would be defamation when two or more persons are involved, right? So that is a case of defamation. So there, with that example, I hope you are in a position to understand what do you mean by the term publication. Publication means the matter must be known to some other persons apart from the person to against whom a defamation statement have been given. In order to better understand, we have two important cases here. The first one is Huth versus Huth in the year of 1915, right? In that case, it is observed that a third person wrongfully reads a letter meant to the plaintiff. The defendant is not liable, right? Because it's not a publication or unauthorized. Means A sent a defamatory letter to B. The letter was reached to B. B put the letter in the safe custody. A thief stolen the letter. A thief stolen the letter, and it was read by the thief. It was read by the thief, right? So this is not a case of defamation. Hence, the reading by the thief is unauthorized. Is unauthorized, right? So hence, we can say this is not a case of defamation. Okay, so that was observed in the case of Huth versus Huth in the year of 1915. Similarly, in 1962, one more case was on that, that is Thicker versus Richardson. It was also talking about the case of the defamation by the letters. In that case, it was observed that where letter sent is in such a way that it is likely to be read by some other one against some other one else, so that will become a case of defamation, right? In this case, a letter was sent and it was sent to the plaintiff, that it may be read by the clerk or the supposed, so that is a case of defamation. Like by ordinary post, a defamation letter was sent by A to B by ordinary post, right? And the nature of the work for B was that he generally was not at his home, and in the home B has his maid as well as the wife, right? And a letter when comes to the house of B, it was opened by the B's wife, right? Because it was sent by the ordinary post, and generally when a letter is sent by the ordinary post, that is opened by some other members of the family, right? So that in the case of Thicker versus Richardson, where it was observed that where the letter is sent in such a way that it is likely to be read by someone else, so that particular statement is said to be a case of defamation. Or we can say where a letter has been sent in the form of the postcard or telegram, or telegram, in that case, that is the case of defamation, right? Similarly, in the modern time, when we put a comment on the Facebook on the wall of the person, if we send a message on the wall of the person, so that it simply means that it's a publication, right? So all these cases were we covered under Thicker versus Richardson in the year of 1962, right? So in that case, all these are said to be the cases of defamation. Next, we have defamatory matter from husband to the wife. It's a very important term here, because number of times the question have been asked, that is a defamatory matter between husband to the wife. It's not a defamation. It's not a publication, right? It's not a publication. For example, A sent some defamatory letter to B, and it was read by C, who is the wife of B. Legal point of view, both B and C are said to be same. From legal point of view, from law point of view, both B and C are said to be same. It's not a publication, right? It means that in the eyes of law, husband and wife both are the same person, right? And a communication of defamatory matter from husband to his wife or vice versa is not a publication. If A communicates something to her wife, or wife communicates something to her husband, that is basically not a case of publication. A very famous case was there, that is T.G. Ponen versus M.C. Varghese, 1917. That is T.G. Ponen versus M.C. Varghese, 1970. What happened in that case, that before going into the English language, just I try to understand the basic understanding. हस्बैंड और वाइफ के बीच में थोड़ा सा झगड़ा होता है, और हस्बैंड अपनी वाइफ को एक लेटर भेज देता है, और उस लेटर के अंदर हस्बैंड अपने फादर इन लॉ के बारे में काफी डिफेमेटरी मैटर लिखता है, राइट? और वाइफ क्या करती है, उस डिफेमेटरी मैटर को अपने फादर को दे देती है, और फादर अपने सन इन लॉ के अगेंस्ट में कोर्ट में जाता है, राइट? हस्बैंड कोर्ट में कंटेंट करता है कि लेटर जो अपने वाइफ को एड्रेस किया था, दैट वाज नॉट दैट एड्रेस टू हर वाइफ, राइट? इट्स नॉट सेड टू बी publication, right? It's not that is admissible in evidence by virtue of section 122. Section 122 of Evidence Act simply states that no person who is or has been married shall be compelled to disclose any communication made to him during marriage by any person to whom he or has to be married, and nor shall be permitted to disclose any such communication unless the person who made it or representative in interest proceeding in which one married person is prosecuted from any crime committed against her. Means ये एक जनरली प्रिविलेज कम्युनिकेशन का एग्जांपल है. हस्बैंड वाइफ के बीच की जो कम्युनिकेशन है उसको दूसरे के अगेंस्ट में यूज नहीं किया जाता अंडर सेक्शन 122 ऑफ द इंडियन पेनल court, right? So what happened in this case? In this case, it is finally stated that husband is liable for defamation, but defamatory statement has to be proved from evidence other than that of the wife. The major point here is that defamatory statement has to be proved other than the wife. Publication has to be proved other than wife, right? Means from law point of view, both husband and wife both are the same thing, right? So what we can say is that in this case, the question was whether a letter from husband to his wife containing defamatory matter against father-in-law could be proved in an action by the father-in-law against his son-in-law because his wife has passed a letter to his father. What court stated that husband is liable for defamation, but that defamatory statement has to be proved from evidence other than that of the wife. Means law point of view, husband and wife both are the same, right? So that simply clears that particular thing, that defamatory matter from husband to the wife is not a publication. That was observed in the case of T.G. Ponnen versus M.C. Varghese 1970, right? Next is communication of a matter defamatory of one spouse to other is sufficient publication, right? Means Thicker versus Richardson, defendant wrote a letter to the plaintiff making false allegation of her being a prostitute. Letter was sent under the circumstances that plaintiff husband in all probability would have read the same. The plaintiff husband opened it and read it. That is the case of defamation and the defendant was held liable. Earlier I also stated you that, for example, let us say one person has sent a letter to B in a letter stating that B is a prostitute, right? And the letter is likely to be read by her husband C. Now, although from law point of view, husband and wife is same, but from the publication point of view, they have to be taken as different. Now, it is a case of defamation, and B can file a suit against A as a case of defamation, right? So that in that case, the defendant would be held liable. That was observed in the case of Thicker versus Richardson. Okay. Next, we have one more case, that is Nemichand versus Khemraj in the year of 1973. What happened? The defendant called a meeting against the plaintiff, and while imputation have been made against him, one of the defendant got those speeches published and printed, and that printout would be in the godown of the defendant. The plaintiff argued that even printing constitutes publication, right? But it was held that mere printing is not actionable. Means until it was not published. By publication, we cannot say that have been printed, a book was printed. There is a difference between the printing and publication. There is a difference in print and publish. When we talk about the print, suppose if I print a letter and put it into my pocket by making a number of false allegations, number of bad words about a person, number of statements that may cause a defamation about a person, until it was in my pocket, it's not a case of a defamation. But if I give that letter to someone else other than the plaintiff, in that case it is a publication. Now that is a case of publication. Okay, so here we can say that mere printing is not actionable until it was published or until it was spread to the other person. In that case, that would be taken as a publication. Okay, so till time what we have understood, we have primarily understood the three essentials of the defamation. What were that? First one is that words must be defamatory. Second one is that the words must refer to the plaintiff, and third one is that words must be published. In that, we also understood one more important term, that is named as innuendo, right? Let's have the third part of this session, that are the defenses to defamation. In case of defamation, what are the defenses available to the defendant in order to save himself? Let us start with one by one. The first defense taken by the defendant is justification of the truth, right? In a civil action for defamation, truth of defamatory matter is a complete defense. Means where the defamatory matter is true, in that case it's a complete defense, right? But in criminal law, besides being true, the imputation must be shown to have made in public good. Two things are there. In the criminal law, although first point is that the statements must be true, the truth of the statement, as well as it should also be shown that there is without any bad intention the statement had been given, right? It should be made for the public good. Only in that case that would be taken as a defense, right? So first here I can easily say now, under law of torts, because law of torts is a civil action, if the defamatory statement, if the defamatory matter is truth, in that case that would be taken as a defense. But if it is under Indian Penal Code 499, in that case, if a criminal action have been taken, in that case, along with the matter to be a truth, the one more thing have to be shown that it should be made for public good, right? The reason for the defense is law will not permit a man to recover damages in respect of an injury to a character which either he does not possess. Primarily means that if a person is a thief and it was published in a newspaper about his character that he is a thief, right, and he goes to the court of law that by against the publisher that a news have been published stating me as a thief because he was a thief, and if a newspaper states that he is a thief, then that is not a, it's not a wrong, right? It's not a case of defamation, right? If a statement is false, no justification that the defendant honestly and on reasonable ground believed it to be true. Means statement must be true. Statement must be true, right? If statement is false and it is stated that the defendant by innocently or without any intention by honestly has taken that, that would not be taken as a defense. What happened that in a case Radheshyam Tiwari versus Eknath in the year of 1985, right? It's a Bombay High Court case. What happened? The defendant, who was an editor and printer and publisher of a newspaper, he published a series of articles against the plaintiff, that is the block development officer, alleging that the plaintiff has issued false certificates, taking bribes, adopted illegal means in various matters, right? In that case, an action of defamation was taken by the block development officer against the publisher, right? And in the court of law, fact published by him were not true. He was not able to prove that the block development officer issued a false certificate without, he does not have any evidence for stating that that block development officer has issued false certificates or he has taken bribe. In that case, it was held that defendant would be held liable. The reason behind it, because the statement that he has stated that they were not true. Because here, when we talk about the defense here, the defense is it is justification of the truth. But if the statements are not truth, in that case we cannot go for any justification, right? So here we can say in that particular case, the defendant were held liable, right? So that is the first defense here, that is justification of truth. Second one is fair comment. Second one is fair comment. When we talk about this term fair comment means without any bad intention. In generally, any comment that has been there, fair means without any bad intention. Fair comment means without any bad intention, without any bad intention, that is said to be fair comment, right? What we can say is that in generally, number of defenses are available to a author, editor, or the critics of the books or newspapers. That defense is available to them, right? Because it is a critical appreciation of the existing fact, right? The comment must be fair without any malice. Malice means bad intention, right? That there should not be any bad intention, right? And the comment must be in the public interest. The comment must be in the public interest. For example, let's take an example. Rohit says of a book published by the Rakesh, right? Because here we are talking about a fair comment. It depends on the statement to statement. Rakesh books is foolish. He must be a weak man, right? Now this comment is not about Rakesh. This comment is about Rakesh book, because after reading the book of the Rakesh, that Rohit has given the particular comment, right? And after reading the book of the Rakesh, because the Rakesh books is such that it seems to be a work of a foolish person, and on that basis he stated that Rakesh must be a weak man, right? So it's a comment or we can say it's a critical appraisal about the book of Rakesh. Okay, so it's not a defamation. It's not a case of defamation. But if I take the second statement, I am not surprised that Rakesh book is foolish, for he is a weak man. Means that now he is commenting that Rakesh is a weak man, and because of that his book is totally foolish. Now just try to understand. It's simply the difference of the language. In the first case, first of all he read about the Rakesh book, and after that he commented that according to the book it seems that Rakesh is a weak man. So it's a critical appraisal of the book of the Rakesh. But on the other hand, when I take the second statement talks about that because he knows that Rakesh is a weak man, and on that he commented that Rakesh book is foolish, right? So here I can say the second case is a case of defamation, but first case is not a case of defamation, right? Because everything is matter of the fair comment, right? We have a very important case here, that is McQuire versus Western Morning News Company 1903. McQuire versus Western Morning News Company 1903. What happened that in that case a comment was in question. It's a comment. I have just mentioned here the comment. By just understanding the comment, we try to say that whether the comment is a critical appraisal about that particular album or it's a case of defamation, right? The comment was that a 3-act musical absurdity written and composed by T.C. McQuire is composed of nothing but nonsense of a not very humorous character, whilst the music is far from attractive. Right? Now when we read that, by reading this, what we can say? Nothing defamatory is said to be against T.C. McQuire. Whatever is stated, that everything is stated about the album or the album music composed by T.C. McQuire, right? So here we can say that that is not a case of defamation. It is fairly called criticism. That is fairly called criticism, and we know that the right of the criticism is available to the every author, that is available to the every editor, as well as available to the every person of India, because we can criticize the work of any other person on fair grounds without any bad intention, right? However, if the criticism is given in such a way that under a cloak an opinion was made to defame some other person, in that case that may be lead to some defamation. But in this particular case, McQuire versus Western Morning News Company 1903, that is mere a criticism. It is not a case of defamation, right? Comment could not be fair when it is based on untrue facts. One more important term here. If the comment is based on some untrue fact, in that case that is not said to be fair. It must be based on some true facts, right? Means if you are commenting on the album of a person, so that album must be of that person. You cannot comment about a person by watching the album of some other person, right? Means the fact on which you are commenting, that must be true. A case was there, Tushar Kanti Ghosh versus Beena Bhomik in the year of 1953. Amrit Bazar Patrika published a news item which contained statement about daylight robbery, right? Statements about daylight robbery which were factually incorrect. In generally, that daylight robbery does not happen, right? In that case, the statements were untrue, the comment was made on untrue, hence defense of fair comment was defeated, right? Means a news was published by the Amrit Bazar Patrika and number of statements have been made in that about a daylight robbery. But when we went into the inquiry whether the daylight robbery happened or not, it was observed that that daylight robbery does not happen, right? In that case, it was observed that because the statement were made on the basis of the daylight robbery and that daylight robbery does not exist, means they are based on the untrue facts, right? In that case, it is given that the defense of the fair comment was defeated, right? Next, we have the third defense, that is said to be privileges. Third defense is said to be privileges. What do you mean by the privileges? There are certain occasions when law recognizes that right of speech overweights the plaintiff right to reputation, right? It means that is generally, earlier I also told you that in the case of the defamation, a balance have to be strike between the right to freedom of speech and expression, between the right of speech, right, and right of reputation. Sometime it may happen that that right of speech overweights the right of reputation, right? That is basically termed as privilege. Law treats the privilege, and a defamatory statement made on such occasions are not said to be actionable, right? So primarily we have two type of privileges. First one is the absolute privilege, and second one is the qualified privilege, right? Let's try to take it one by one. First one is absolute privilege, right? It's an absolute defense that if no action lies for defamatory statement, even though the statement is false. Sometime it may happen that a statement is being made and statement is false. Still no action can lie against that defamatory statement, right? What at what particular point that generally happens in parliament proceedings, in parliamentary proceedings. Suppose in the proceeding of the parliament a debate is going on, and by a member of parliament has given a statement about defaming someone based on a fact, and later on it was found that the fact is not true. So that is an absolute privilege available to that member of parliament during the parliamentary proceeding. Anything stated by the member of parliament during the parliamentary proceeding is covered under absolute privilege under our Indian constitution, right? Similarly, in judicial proceedings, there cannot be any action against judge, counsel, witness or any party for words in court of proceeding before court, even though the words were written or spoken maliciously without any justification or accuse, right? Means suppose a case is going on, and during the trial number of malice questions have been asked by the lawyer from the witness, right, or from the defendant. So in that case, that lawyer is under absolute privilege, right? No case of defamation can be taken against that particular lawyer. And similarly in state communication also there is a case of absolute privilege, right? So what we can say that now what we have understood from the term absolute privilege, that by the term absolute privilege, in that anything whatever is stated, no action of defamation can be taken against that, right? That's a case of absolute privilege. Generally the three aspects are being covered in that. First one is parliamentary proceeding, second is judicial proceeding, and third one is state communication. Anything is stated in parliament session or in judicial proceedings or in state communication, that is covered under absolute privilege. No action of defamation can be taken against them, right? Second one is qualified privilege. Second one is qualified privilege. Qualified privilege means action can be taken, right? But if some conditions are fulfilled, in that case no action can be taken, right? It's different from the defense of the absolute privilege, right? What is important here? First one is statement must be given without any malice, without any bad intention, and second must be that there must be some occasion for giving the statement. If a statement is given without any occasion, in that case that cannot be taken under qualified privilege. And the second thing is that if the statement is given with a bad intention, right, in that case also that could not be taken as a defense, right? Such a privilege is available either when the statement is made in discharge of a duty or protection of the interest, or publication is in form of the report of parliamentary, judicially or other proceeding. Means while discharging the duty, because here because there I told you that it must be given with any malice, as well as there must be some occasion for that, right? Means while discharging the duty, if a statement had been given, right, so that may come under qualified privilege. Otherwise, if the statement, if by the same person, if that statement is given while he was not at his work, then in that case that may go for defamation. But while discharging the duty, if that statement is given, then in that case that will come under the purview of qualified privilege. And second one is protection of the interest, right? So that is a case of qualified privilege. Okay. Next we have, let us say a few more examples here for qualified privilege, right? It's given that publication of a character of an employee by the former employee with a motive to harm the servant, right? It's not a case of qualified privilege. For example, मेरे पास एक नौकर काम करता था, मेरी उससे नहीं बनी, मैंने यहाँ से काम छोड़ दिया, मैंने एक न्यूज़पेपर में उसके कैरेक्टर के बारे में छपवा दिया, ठीक है? आप इस बात को मानते हैं अगर कोई नया मेड या नौकर कहीं ज्वाइन करता है तो एम्प्लॉयर पहले उसके प्रीवियस एम्प्लॉयर से बात करता है, ठीक है? तो इस केस के अंदर it was the bad intention of the previous employer to harm the servant, right? So that is not covered in the case of qualified privilege. Similarly, the second case is statement made by the owner to his servant. For example, A is a shopkeeper. He says to his servant B, who manages the business of A, sell nothing to Z unless he pays you ready money, right? Because I have no opinion of his honesty. Okay. So A is protected if he has made the imputation on Z in good faith for the protection of his own interest, right? So just take it from any other part. Statement made by the owner to his servant not to sell anything to X on credit because I have no opinion about his honesty. It's a qualified privilege because the statement is given by the person in order to protect his interest, right? Hence I can say that is a case of qualified privilege, but first one is not a case of qualified privilege, right? Similarly, statement made in confidential relationships are also under the qualified privilege. What do you mean by this? Confidential associations between husband and wife, father and his son or daughter, right? Guardian and the ward, master and servant, solicitor and the client, between the partners, between the close friend, right? For example, let us say A is the daughter of B. A wants to marry with a boy C, right? And father tells A about the bad character of C. The father B tells A about the bad character of C, right? So in that case, because A wants to marry C, so that stating about the bad character of C, it's not a communication against C. Why? The reason behind it, because that is given under the close relationship or confidential रिलेशनशिप, ठीक है? मतलब इसको जनरल समझें, बी अपनी बेटी जो सी से शादी करना चाहती है, तो बी अपनी बेटी को कहता है कि आप जो सी से शादी करना चाह रहे हैं, सी का करेक्टर अच्छा नहीं है, उसके करेक्टर के बारे में कई बातें कहता है. तो इस केस के अंदर सी बी के अगेंस्ट में कोर्ट में डिफेमेशन का केस फाइल नहीं कर सकता. रीजन क्या है? रीजन इसके पीछे ये है क्योंकि बी और ए के बीच में जो कम्युनिकेशन है वो क्वालिफाइड, that is covered under qualified privilege. The reason behind it, that is in confidential relationship. Okay. Next we have malice destroy the defense of qualified privilege. Earlier I told you that for the qualified privilege, bad intention is the first thing, right? There should not be any bad intention. Okay. The plaintiff must prove actual or express malice or malice in fact, right? The plaintiff has to show that the bad intention must be actual or express with the facts of the case, right? Sometime the intention may be implied, right? Law presumes from the mere publication of a defamatory matter, they are in a position to presume that whether the intention is there or not, right? So the idea is here that there should be must bad intention. It may be expressed or implied, right? Next we have the last topic of this chapter, that is the defamation, that talks about the burden of the proof. That talks about the burden of the proof means if in case of a defamation, who has to prove in the court that whether the statement is defaming the reputation or not, right? It is the plaintiff who has to prove. It is the plaintiff who has to prove, right? Thus, for an innuendo in special circumstances, the plaintiff must make out a special circumstance which made the word actionable, right? And he has to show in the court that that has a latent or secondary meaning about the defaming the person, right? When the defense of defamation is taken by the defendant, in that case the burden of proof is on the defendant, right? But here idea is that who is talking about the defamation, that person has to prove in the court that whether it is a case of defamation or not, right? fair comment or misstatement of fact, the defendant has to show, because that defense has been taken by the defendant, right? For taking any of the defense, so that has to be proved by the defendant. Okay. In defense of the privilege is qualified, the defendant has to prove that the occasion is of the qualified privilege, right? It means at the starting of the case, first of all, the plaintiff has to prove whether it is an action of the defamation or not, right? And at the time of taking the defense by the defendant, then defendant have to prove that the old defenses have to be proved by the defendant, whatever defense he is taking, right? In case of libel, it's not necessary to prove the actual loss of reputation. It is sufficient to establish the defamatory statement could damage one's reputation, right? So here one important thing is that while proving, there is no need to show that actual loss have been occurred, right? Here important point is that the defamatory statement could damage one's reputation. Okay. Further, in case of joint publication, each defendant is liable for their ensuring their damage. For example, in a libel, a newspaper editor, printer, publisher are liable to be sued either separately or together, right? Means when number of persons are involved, so each defendant is liable. The next point is who can sue, who can initiate the case of defamation, right? The publication of a defamation can give a right of action to anyone but the person defamed, means the person who has been defamed. Earlier I also told you that it must be towards the plaintiff, right? The person who is actually defamed, that person can only initiate the case of defamation. Okay. The defamatory statement has caused damage to other person does not entitle them to sue. I told you number of cases that in case of a defamatory statement against spiritual head of a community, right? In that case, no other member of the community can go for the case of defamation. Similarly, in case of defamatory statement to the whole class, in that case also, no particular person of the whole class can go for the case of defamation until he proves that the statement particularly talks about him, right? Similarly, in case of partnership firm cannot go for that particular case. Partners can go, right? So here I can say that who can sue? Only the plaintiff can sue against whom the defamatory statement have been given. Some exceptions are also here, as in case of a deceased person. In case of deceased person, law of torts does not provide any remedy, right? But under IPC explanation 1 of Indian IPC section 499, in that case the remedy is available, right? Similarly, so here we can say that similarly, damage to other person does not entitle a person them to sue. So what we can say that a brother cannot sue for slander of his wife, right? Means if some bad statement is talking about the wife, talking about the sister of A, so A cannot take an action of defamation, right? Similarly, father for defaming his daughter, not the heir and the nearest relation of the deceased person, right? But Calcutta High Court permits the husband to sue where unchastity is imputed to the wife, right? But there is a confusion between the different high courts also, because no specific law is there, right? What we can say that in generally, as a thumb rule, what we can say, only the person who has been defamed, he can sue in the court of law, right? So that is end to our session on the topic of the defamation. In this session, what we have understood, a number of things we have taken. First of all, we try to understand the meaning of the defamation, then what are the essentials of defamation, as well as what defenses could be taken by the defendant in order to save himself in the court of law. Thank you very much. I hope you enjoyed the session. So that is end to our session on the topic of defamation as a preparation for the judicial services examination on the topic topic law of torts. You may send your feedback to me at my email ID legalbuddy@gmail.com or my WhatsApp number 092-155-14435. I expect from you to share these videos on your Facebook wall as well as with your friends, so that they will also be benefited by this. Thank you very much.